Hello, Nation of Immigrants. As you can see, it's Lawyer Up Friday again. Here in the office, we wear these t-shirts every week. On Friday, and we kind of dress down. Today, though, we're going to be talking about fake immigration court dates. This is an interesting topic. It's related to kind of a broader set of topics that I have given public presentations on. I spoke related to this topic at the Virginia State Bar Annual Conference this last summer. And so it's just interesting. Why are we really giving fake immigration court dates? The answer is yes. But why are we doing that is something we'll be talking about today. And so welcome to Nation of Immigrants. I hope you enjoyed today's episode.
You're listening to Nation of Immigrants.
America is a nation of immigrants.
A podcast about U.S. immigration law with your host, Jacob Tingen.
Okay. Thank you again for listening to Nation of Immigrants. As I've been mentioning the last couple of episodes, we are accepting donations to help support the podcast. And the idea is that you're not just supporting the podcast, but you are supporting immigrants. We're going to take those funds and put them towards immigrant legal bills. And we'll be setting up a 501c3 soon, but you can, of course, donate now. Okay, so as I frequently do when I'm about to do a Nation of Immigrants episode, I literally just check the news. I Google immigration news. And one of the headlines that caught my eye today is this one from the Miami Herald. Fake court dates are being issued in immigration court. And that might be news to some people, but for practicing immigration attorneys, it's not news. It's crazy that this is a real thing, but it is a real thing, and we're going to talk about why that is. So what's actually going on here? Well, the last big immigration reform we had, which I guess was the last time Congress could cooperate together on this issue, was in the 90s, right? And you know, I think there was a change between, they changed, it's no longer deportation proceedings, it's removal proceedings, which is a technical difference, I know. And then additionally, in that kind of adjustment, there were some laws that were issued. Immigration proceedings begin with a document called a notice to appear. And what the notice to appear does is, the way I explain it to my law students and other lawyers when I give presentations is that it starts a very formal conversation where the U.S. says in letter format to an immigrant a number of things. At the top of the page, it has their name and the date and that kind of stuff. And then it'll list what are known as the factual allegations. And then closer to the bottom of the page, it will have a section where it says you are charged with removability as follows. And it'll cite something from those grounds of inadmissibility that we've talked about from INA 212, or sometimes grounds of deportability. And then at the bottom of the page, it'll say, you know, you need to appear in immigration court, and we serve this document on such and such a date. Okay. So this formal document, the NTA or the notice to appear, the allegations are factual things like, you're not from here, right? So that's one of the first things that it'll say is you're not from the U.S. Instead, you are from another country. You're not from here. You are from another country. You do not currently possess appropriate documents. You entered the U.S. on or about certain date. And then it'll skip to the charge and say, by the way, for those reasons, you know, you're deportable. And so when a immigration attorney gets a client, typically, I'm going to ask to see their paperwork and try to find this notice to appear, the NTA. It's going to have an identification number known as the A number, the alien number on it. I can use that to kind of figure out when the court date actually is. Now, at the bottom of the page, like I said, it'll have information like you must appear in court on a certain date and a certain time. Now, that's required by statute, that a notice to appear should say when and where you have immigration court. Now, of course, for an immigrant coming into the country, may not know exactly where they're going to be living, it can be difficult to know which immigration court they should appear in. And so a lot of times, instead of listing an actual court address, it'll just say you are required to appear at and then it'll say to be announced or to be determined immigration court on a date to be determined at a time to be determined. Now, one of the things that is frequently said about immigrants and their court dates when they come over is one of the criticisms, I guess, is that these immigrants don't even show up to their court date. Now, if this is the first document that they receive, the notice to appear, and this says you are in removal proceedings and you don't really speak English because you're an immigrant, and they give you a paper that says, by the way, you have to appear at a court somewhere in the United States at a date sometime and at a time sometime, I'm going to give them the benefit of the doubt and say it's reasonable that they don't show up to that court date, because how are they supposed to know? Now, of course, they are typically communicated in one way or another. You need to keep your address updated with the immigration courts, with the service. There are a lot of alternative to detention programs that require immigrants to check in with people. So there is an effort to try to maintain, good records. But I think if we determine what happens in immigration court influences the rest of some people's lives, right? And so, well, everybody in immigration court, what happens affects their lives. But if that's the process, if that's the standard that we're going to live by, is all like, you know what, you've got court someday, sometime, somewhere, and then they don't show up to immigration court, and then we enter what's called an in absentia order of removal if they don't show up, then I think that probably leads to a lot of outcomes that aren't fair. Okay. Now, originally, like I said, for a notice to appear to be valid, it has to include that place name and address. It has to include an actual date and an actual time for removal proceedings. Basically, it makes sense. If I'm going to put you in a process where you have to appear in court, I'm going to tell you when and where and how to do that. And so that's required by statute. Now, from a regulation from about the 2000s, and this is one of those other issues, by regulation, the service decided that, you know what, we're only going to put time and date information where practicable. That's what it says. Only where practicable. And so from about 96, 97 to about the year 2000-ish, virtually every NTA had a time and date because, CBP and those guys coordinated with the immigration courts and worked out dates. I don't know why the regulatory change. I don't know why where practicable came into the picture. But since that time, since that regulation, virtually 99% of all notices to appear have been issued without a date and time. Okay? So again, when pundits or other opinion leaders say, well, these immigrants don't even show up to their court dates, that's unfair. It's really, again, hard to say, well, they didn't show up to their court date when we didn't even tell them when they needed to show up. Now, technically, again, if they maintain their address with the immigration court will subsequently send out a notice of hearing, and that should get resolved. But inevitably, these kinds of issues lead to big problems. And one of those big problems came to head in a Supreme Court opinion that was issued last year called Pereira v. Sessions, simply because Jeff Sessions was the Attorney General at the time. But Pereira was an immigrant, and the fact pattern is something like this. Basically, he had been arrested on an immigration violation after about 7 years in the country and was given an NTA, a notice to appear, which did not have a date and time for his removal proceedings. Now, I believe in the fact pattern, surprise, surprise, he was mailed a subsequent notice to a notice of hearing so that he would actually appear at the immigration court date, but he never got it, right? And so then subsequently he was arrested at about 13 years of presence in the country and said, whoa, I never got my day in court. You can't deport me. And so then they reopened proceedings because they said, okay, you're right. You didn't get your day in court. But then because even though he'd been arrested at 7 years, because he didn't actually get his first court date till about 13 years in, he tried to apply for a form of relief called cancellation of removal, non-LPR cancellation of removal. We won't get into the technicalities of that, but one of the requirements to apply for non-LPR cancellation of removal is that you have been present in the U.S. for a period of 10 years before service of the notice to appear. Well, his attorneys looked at the notice to appear and said, well, this is not a notice to appear because it did not list the time and date information. So he wasn't ever actually served with a notice to appear. And so his time continues to roll on past 7 years. Now, I believe that's reasonable. And so did the Supreme Court. Ultimately, the Supreme Court decided in an 8-1 decision, so almost unanimous, that this document that had been served on Pereira did not meet the qualifications of a notice to appear under the statute. And so it didn't begin or cut off the stop time rule for applying for cancellation of removal. So basically they said, you can still apply for cancellation of removal because you were here in the U.S. 10 years before you received a notice to appear, and you didn't receive a notice to appear. So that's what happened in Pereira. And one of the things that the Supreme Court said in their decision was, hey, and by the way, you used to coordinate with the immigration court and put on dates. So why not do that today? Like, it's 2018, people, and now it's 2019. We have things called computers. I'm sure that you could pull off some kind of coordination and get a real date on some of these notices to appear. And it's interesting that on appeal up to the Supreme Court, the government argued, hey, look, if we have to put dates on this, we're just going to put fake dates. This is going to lead to results where they're just given dates that aren't real dates because, they're not coordinated with the immigration court. And the Supreme Court said, no, you can coordinate dates. Like, why wouldn't you? This is totally possible and doable. Coordinate with the immigration courts and put dates on these notices to appear. Well, that gets us to where we are today. In the aftermath of Pereira, people were receiving notices to appear that said things like, show up to immigration court at such and such a place on September 31st. There is no September 31st. Some people were issued notices to appear on September 32nd. And if you don't know that that's not a date, I can't help you. So anyway, other people have been issued notices to appear for November 31st, right? And so these dates were just being put on these notices to appear, fake dates. Sometimes they were given dates that do exist, like, September 14th or whatever, September 20th today, right? So let's say that they're given a date for today, but that's never communicated to the immigration court. Well, an immigrant might show up today and the court will be like, well, we didn't know that you were going to be here. Nobody ever told us that we needed to have proceedings for you today. Why don't you just come back later? Make sure your address is up to date and we'll send you a notice of hearing whenever you do have a hearing, right? I have literally showed up to immigration court and seen it 3 to 4 times more crowded than normal and asked what's going on. And I remember one immigration attorney colleague of mine said, oh, it's fake date day. And we both just kind of laughed because we know what fake date day is, right? I mean, basically they just pick a date and just put that on a bunch of NTAs and people show up for court because they do care. But then when they don't have a court date, not really, what does that say about the process? What does that say about fairness? A lot of these people take off work. A lot of these people have to pay for transportation. And a lot of these people spend a lot of money appearing for fake court. And so that's a problem. There are other problems in terms of scheduling immigration court hearings. People are supposed to be receiving notices of hearing at least 10 days before a hearing. We're seeing with our clients that sometimes the court will issue notices of hearing less than 10 days prior to a court date. We'll have people get a notice of hearing the day that they have to show up for a hearing. And it's 2 hours away and we're in Richmond. So these are the kinds of problems that immigrants are facing. And we're still seeing today, I mean, it's been more than a year since Pereira, and we're still seeing that people are coming from the border with either it'll say to be determined on the notice to appear, so they're not even bothering to put even a fake date, or we'll see occasionally fake dates. It's alarming that this would pass as an okay standard operating procedure when it's clearly not. And so, fake court dates are being issued in immigration court. Really? Is this really happening? Sadly, the answer is yes. Can this possibly lead to fair results for any immigrants? No, of course not. If a police officer gave you a ticket for speeding and said, by the way, I need you to show up in court here locally. And he gives you the sheet of paper and it has a spot for date and time. And those are blank. What do you say to the cop? Hey, you didn't put a date and time. What if he takes it back and writes, oh, okay, let me fix that. And he writes TBD on it, to be determined, and hands it back. Aren't you going to be a little upset with that? Is that fair for you? Is that going to actually help you show up in court at any time? Of course not. So this is a big problem. And yet it is an ongoing problem, and it's a problem that immigrants face. So that's just a taste of what's going on in immigration court today. I do have kind of a series of videos about immigration court that I'd like to share. We'll of course see if we'll start that series of videos or not, depending on current events. So again, before I do these things, I typically Google immigration news, and so far it hasn't failed me. There's been virtually something different every single day. It's been amazing. As a final note, I did want to give one quick update on the whole medical deferred action issue that was happening, where they canceled deferred action for people, many of whom were children with life-threatening illnesses and diseases. USCIS did reverse that policy, and they are now again considering deferred action for children facing life-threatening medical illnesses. So that's good news on the immigration front. It's nice to be able to share that once in a while. It is bizarre that we had to have it canceled to begin with, but there you go. So once again, Nation of Immigrants, thank you for listening. Don't forget to subscribe on YouTube, follow on iTunes, Facebook, Twitter, both the firm and my personal website, TingenWilliams.com and JacobTingen.com, where we'll be sharing, helpful legal information and tips about immigration and a lot of other issues. Thank you so much for listening, and Nation of Immigrants.
Thank you for listening to Nation of Immigrants.
America is a nation of immigrants.
Subscribe to the podcast on iTunes. Watch the live stream on YouTube and Facebook, or visit JacobTingen.com to learn more.